What are 3 things you need to know as you are preparing for your pre-trial deposition? You want to know the answer? Come join me on this walk through the neighborhood as I share with you exactly what I'm talking about. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. During the course of your lawsuit, you will have to give answers to questions that are being asked of you by the defense attorney, the lawyer who represents the person or the people whom you have sued. We call this a deposition. It's also called an examination before trial. It's really pre-trial testimony. And now, what happens? You appear in your attorney's office. There's no judge there. There's no jury there. This takes place in the conference room. But there is a court stenographer there to record all of the questions you are being asked and all of the answers that you give. And even though there's no judge or jury there, the answers that you give carry the same exact weight as if you are testifying at the time of trial. So now, this causes a lot of concern, a lot of anxiety for people who have never gone through this process before. So let me share with you 3 tips. Here we go. 3 tips that I think will be helpful for you in order to go ahead and prepare in anticipation of your deposition. And by the way, in the days leading up to your deposition, your attorney will spend a great deal of time actually preparing you and going through with you the types of questions you are likely going to be asked. All right, so let's start off with tip number 1. Tip number 1 should be pretty obvious, but a lot of people don't realize it. When they walk into the conference room, they see the opposing attorney. What do? They introduce themselves. They say hello. They're polite, they're nice, they're kind. That's fine, but you should know something very important. The opposing attorney is not your friend. The opposing attorney will never be your friend during the course of the lawsuit. The opposing attorney is there to learn information about you in order to use it against you at the time of trial. So keep that in the back of your mind. No matter how friendly, no matter how nice, no matter how polite the attorney is, he is not your friend. Tip number 2. The purpose of a deposition is not to give you the opportunity to tell the opposing attorney every single thing that happened to you and every single thing that you know about the events that transpired leading up to the lawsuit. That is not the point. A lot of people who are injured and now they bring a lawsuit, they can't wait to go ahead and tell their story. They can't wait to go ahead and tell the opposing attorney every single detail of every single event. And you know what? Tip number 2 is, this is not your opportunity. This is not the time for you to tell the opposing attorney every single detail of everything that happened. You want to know why? It's because the deposition is part of the discovery process. The defense attorney, the attorney who represents the people or the person you have sued, it's his opportunity to go ahead and ask you questions. If the defense attorney fails to ask you key questions, that means he's lost the opportunity to get those answers. It is not your opportunity to fill him in. It is not the chance for you to go ahead and disclose to him information that he has not asked you about. That is not the purpose of your deposition. So, we now know number 1, which is the defense attorney is not your friend. Number 2, you are not there to go ahead and tell the defense attorney everything that happened to you in exquisite detail. And number 3, you are to answer only the questions that you are asked in yes or no fashion if it calls for it, except when it comes time to discuss your injuries and the current problems that you have. In that instance, I will always tell my clients, it is now your green light. It is now your opportunity to explain. Why is that? It's because the defense attorney, even though they have copies of your medical records, they don't live with you each and every day. They don't see what goes on behind closed doors. They don't see what happens as you get ready for bed each night. They don't understand the pain that you're in. They don't have a full picture of exactly how these injuries affect you on a daily basis. It is key for you to be able to explain to the defense attorney and give him a picture, paint a picture in words of exactly how these problems affect you on a daily basis. How have they altered your daily activities? And by doing that, it gives the defense lawyer an opportunity to really picture in his own mind exactly how your injuries have impacted your life. So why do I share these 3 quick tips with you? I share it with you just to give you a sense of what really happens as you're approaching your deposition, your pretrial testimony, and now you're getting anxious, you're getting concerned. What's he going to ask me? How should I approach it? What should I do? Your attorney will cover all those things, but this gives you a heads up and it gives you a sense of, okay, this is what I need to think about. I need to remember these things. Why? Because if you do that, You will have a much better outlook on your pretrial testimony. You will have a much better outlook on what the defense attorney is trying to accomplish and what information he's trying to look for. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.